I kind of found that employment, I sort of gravitated towards that because it was a real human topic, like a human type of law where you are dealing with people and you're making a difference to people's lives, and it's not some dry kind of dusty paperwork subject. Like a lot of comlit was looking at contracts between companies, and the devil was in the detail in the paperwork and finding this clause and what does that clause mean, and getting a chitty and contracts out and trying to dust down some old chancery law. Whereas employment was really more who said what when and what happened. It's like a scenario that took place. Often it might be one incident or like a whole build-up of scenarios over time, but you're much more into sort of psychology there, and actually about and trying to see solutions to problems by thinking laterally. So it's not necessarily, you don't even need to necessarily use the law at all in the law of employment. So for example, let's say your client is being constructively dismissed, right? I don't know how much I don't know what point you know what constructive dismissal is, but it's where you're kind of being forced to resign. And you're representing that client. Ideally, you want to get them out of that job, but they don't just want to leave because they don't just want to kind of leave with their tail between their legs and just go home and cry into their cornflakes and get depressed and then maybe be out of a job and go travelling. Or they want to feel like, perhaps they want to feel like they got a fair outcome, or perhaps they feel like they want to get justice out of that situation. So for them, by negotiating them an exit package, you're actually going to do a lot for their confidence, and you're going to help them like leave with their head held high. So for them, they're going to feel like by getting a decent deal at the end of the day that you've negotiated for them, that kind of symbolises that they've been hard done by, mistreated or treated unfairly. So it's not just about the money, but you're helping with that. And in that scenario, one of your biggest negotiating chips is a bit like poker, and which card you play, but like keeping them in their job. So that refusing to resign. I mean, that's your biggest thing actually, because the employer wants to get rid of them at this point. If you think about it, often this happens that say the new CEO comes in, right, to a company, and they want to bring their people with them from their old company, and they just want the current people just out, and they might not have done anything wrong at all, but they might have been there a long time. So you can't make them redundant, because I don't know how much you know about redundancy, but the role itself needs to be made redundant. So it needs to be a scenario where there is no role available. Well, that's not going to happen here because we're just swapping people in for other people. There's no redundancy. So really, but just dismissing them because actually we want our own people, that's a bit, it's not political in the sense of it's not sort of party politics, but it's, really it's a bit political. It's just like saying, well, I don't like your face, whatever. After 2 years, you've got rights. Okay, you've got unfair dismissal rights under the Employment Rights Act. So you can't just be got rid of. You need to be, if you're going to be dismissed, it's got to be for conduct or capability reason. So conduct being, punching the boss, classic, extreme example. Capability is your rubbish at your job. Again, sort of paraphrasing a lot of, so just not being face-fitting right or not being mates with the CEOs, that's not a reason. So they would have to pay you off. Obviously, they'd have to offer you a settlement agreement, at least to cover the loss that you're going to incur whilst you're finding a new job. So that's your quantum, if you like, when you're going to court and you're going to a tribunal and you're trying to get sort of compensation. You're not getting compensated in employment law really for injury to feelings, really, unless there's a discrimination case, which I'll come back to. What you're getting compensated for will be a lot more about the financial loss you suffer whilst you're searching for a new job. And the more senior you are, the longer you'll be out of a job. So if you're, like a really big fish in a small pond, you're not going to really find that job, that CEO job or the FD job or whatever job, that quickly. You might be out of work for 6 months. So 6 months salary is what you're kind of looking to get in negotiation there. And they don't want to give you that money. I mean, that could be a lot of money, especially if there's a whole team going. So what they'd rather do is in a lot of scenarios where we get called in, they'd rather kind of force you out, but in a kind of subtle way, so as not to be seen to be doing that. One classic way of doing that would be role erosion. So role erosion would be, you suddenly find your role, piece by piece, your role is being given out to other people. So one day you come in, and this task that you have, which is chairing this meeting or setting this agenda or, organising this project or managing these people, well, that's been delegated out to someone else. The next day or the next week or the next month you come in, something else has been taken off your desk and put on someone else's desk. It's like the kind of death of a thousand cuts, right? Then one day you find yourself with no role left anymore, and then you can get made redundant because your role doesn't exist anymore, so we're making that role redundant. Really, that's been planned. And HR, a lot of their job, I am potentially a bit biased because I only do claimant stuff, so I'm just gonna let you know there's great HR people out there, and I'm sure you can get a talk from them and they'll tell you their side. But certainly a lot of what HR need to do is how to get rid of people without being sued, so without sort of breaking the law or trying to fall foul really of the law, because let's face it, the law is really a grey area in a huge amount of that keeps us all in jobs, right? If the law's a grey area, if it wasn't a grey area, there would be no lawyers. So there's lots of subtle ways of getting rid of people so you don't get sued. Role erosion is one of them. Anyway, you're in this situation, you've got a role erosion scenario, or any number. We come back to role erosion specifically. The way you would deal with that would be by working under protest. So you would want to log each of these scenarios that comes off your desk and puts on someone else's desk. Send that email. Say, look, I feel like I'm being targeted here. My role is being eroded. So I was managing this project. I was chairing that meeting. I was doing whatever I was doing. So each time that happens, log that in an email and in writing. Submit a grievance as an option, always. But ultimately, staying employed, and there are a number of other scenarios with constructive dismissal. Do you see how something like staying employed or something like sending an email or putting in a grievance, that isn't mentioning the law really there at all, really. I'm not relying on, what am I relying on really? Section 98A of the ERA, that you want my unfair dismissal rights. But that's not a technical argument. So you don't really, often when lawyers come in and they work for me, and we really just recruit very senior lawyers, but because the way we do it, with minimal supervision, just recruiting very senior people who are just, straight in at the deep end, and they're sink or swim. And after about a week with me, I will often decide, well, this person is clearly not suited, or maybe they are really good, or we'll just carry on the trial. But there's no sense of having to train people, or so you just never know when someone's going to be good or not. So you can get technically very good lawyers who are great, perhaps academically, almost judge-like kind of material, be perfect judges, super brainy, they know all the law, but in fact they're even really great employment lawyers, but when it comes to negotiating a deal, they can't negotiate a deal because they don't really understand enough about human emotion and psychology and behaviour. I mean, I often think negotiating a deal in employment law is a little bit like selling a car or a house or something. I mean, I don't know how many of you sold houses or cars or anything. I mean, has anyone ever sold anything at all? You've sold something. So getting someone here sold something. So yeah, there is that element in there where you're kind of selling a scenario really, to the other side. Like, this is why my client has been badly treated. This is why they should get an exit package deal, a settlement agreement, which is so I don't know if you know what settlement agreements are, but that's when when you've negotiated an employment deal, you sign a settlement agreement document. That effectively means you walking away from that job, you're giving up your rights to sue that employer, and in return they're giving you some money. So when I say exit package, settlement agreement, that's interchangeable. So by kind of coming in and, it's a bit carrot and stick, really. So on one hand, you're persuading the other side, right? Look how badly treated they've been. They've been the model employee for how many years, and suddenly you're doing this to them. And often, HR or higher management don't realise what's going on. Often it might be their line manager. Maybe they've got beef with their line manager. They just don't get on with their line manager. Okay, that's another classic. You can get a lot of people in management are a little bit tapped. Basically, they can be overbearing. They can be slightly, they can want to micromanage people. They can be a little bit power hungry. They can be all sorts of. People make it into management positions in big corporations. I don't know if you've read any of what's that book which suggests that people who get really high up in big corporations are actually just psychopaths. Have you ever read that? It's like a type of person that basically is like a completely Teflon, not affected by anything. Like any problems, they can get out of these problems. They can kind of smile when it's all crumbling around them, and this quarter's figures are absolutely awful, but they're putting on like a brave face. I always think of like Bob Diamond from Barclays, the guy who was disgraced for rigging is he rigging Libor or rigging Libor. Some of these guys are they'll smile at you, and then behind your back they'll be trying to dismiss you, trying to get you fired, trying to kind of give you like rubbish projects that are bound to fail, that just to kind of get rid of you. And so and there's the funny thing is with employment law, there's almost unlimited amount of scenarios of things that could actually happen at work. It's almost like anything that could happen in the playground or in the home or on the street or anywhere like that. There can be an equivalent scenario at work. I mean, you guys may have had jobs before you were students here. You can think of things that have happened at work where we see a lot of a huge range of different, from these kind of more subtle sort of role erosion things to people being accused of fraud, or people blowing the whistle on other types of corporate malpractice, some of the more interesting stuff. So there really is like a huge, almost unlimited range of things that could happen. And in your toolkit of dealing with that, there's a lot of tactical responses that you can actually kind of employ, for want of a better word, to solve them. So, staying in work, or often if your client is stressed and anxious, I would say to a client, well, look, we're not doctors, but you've got a doctor, so why don't you go to your doctor, and if your doctor signs you off sick, then then ultimately, especially if you've got paid sick leave, then you're going to be on the payroll there, you're going to be getting paid whilst not being at work. So for them, that's another reason to come to terms with you, to reach some terms with you, to settle your case, right? To give you an exit package. And people think, oh God, is that skiving, isn't it? Or God, that sounds a bit low doing that. But really, if you're feeling anxious or stressed because of something at work, your boss is making your life hell, which is, it's a lot of people out there. I mean, that's millions of people that feel like that out there. Then that can affect you physically, or even mentally. That's kind of a mental illness, really, isn't it? Stress, anxiety. So I'm not saying it's a disability under the Equality Act 2010, which is a lot of what we have to deal with in employment, which is defined as something which affects you for over a year. Okay, so 12, you have to be disabled under the Equality Act. You have to have over a year of what might be likely to affect you. But if you're having a short-term bout of stress or anxiety, okay, it's a bit like having a cold or having flu or having an injured knee or broken toe or something. You know, that's going to heal hopefully if you remove the cause, if you treat it. So perhaps if you leave your job or if you go off sick, I mean, ultimately that's what sick leave is for, is when you're sick. So that's the type of sickness. But there's another example of something which is not a legal response to a problem. But being lawyers, I mean, a lot of it is, it's almost like some of it is like being an HR person for employees. Because HR people, obviously, they're there on paper to help employees, but if you look at the reality, is that they're obviously paid by the company, and they're actually there to help the company. So they're trying to maximise, you know, what the company gets out of the employees. They're not really there when things hit the fan. They're not really there for the employees. Okay, I mean, yeah, I mean, we even have HR people as clients who are kind of on the receiving end of the treatment that perhaps their senior people are dishing out to them. So it's kind of like being there for the employees, and yeah, you probably want to be that kind of person who, if you're on the sort of the claimant side anyway, who enjoys helping people with their problems and who kind of enjoys a bit of psychology and understanding how to kind of solve a problem, you know, which is like an ongoing problem at work. So it's kind of different from criminal defence, which is very psychological as well and about helping people as well. But that's almost always a scenario that's happened in the past, whereas in employment it's often happening in the present. So this is someone who's at work every day perhaps, and you're having to kind of, and you know, also they're still working perhaps a lot of the time, so it's not so extreme like in crime. Obviously, like lots of bad stuff's happening. This is more kind of just trying to get a fair result really for your client, and it's one of the things I really love about it. I've got a couple of case studies. So I had this case recently by my friend. We'll call him John, and you know what's happened with John is that he's working in Manchester, where he's always worked, and then he takes a new role. The company's restructured. This is another big scenario, like a restructure. Okay, I don't know if it was a merger and acquisition or some sort of why it was being restructured, but it's being restructured, and he's offered a new role. So he's offered this new role and talks to the guy, you know, his line manager, I think it is, accepts the role, and then a couple of months down the line, he's told, right, you now need to work in Birmingham for 2 days a week, I think it was, or yeah, I think it was 2 days a week. So he's there saying, well, I live in Manchester, you know, this is Birmingham, he has a baby, so he's got a baby at home that he wants to kind of be home on time, and he's seeing this as like a 2-hour commute each way, and he's seeing that as a quality of life issue. Now, just a quick show of hands, in general, who thinks that would be a breach of contract? Who doesn't, and who's not sure? So, who's not sure? Okay, and who thinks it would be? And who thinks it wouldn't? Okay, good. We've got a bit of everything there, so everyone's said different things. You know, it's not a trick question. You'd want to look at the contract itself, but in general, contracts of employment often they would allow the employer to send you to work in a different location. So your starting point would probably be, well, this is probably unlikely to be a breach of contract, or maybe 60-40, less likely, but let's look at that clause in there anyway, and let's see what it says. So it says in there, okay, we may send you to a different location. So, right, then you're in difficulties then. So then what are you going to do? So what I said to him is, all right, John, in this meeting you've had, with your line manager, did you discuss location? He said, yeah, it was agreed that it would be in Manchester. Okay, fine. So, okay, that's a verbal contract. So that meeting right there, that constitutes a legally binding verbal contract, whereby you've agreed with your employer to vary your written contract. So your written contract says that you can work in a different location, but you now have a verbal contract, which says you work in Manchester. So we put together this without prejudice letter. I mean, I don't know, does anyone know what without prejudice is? You've covered that, right? Put together this without prejudice letter saying, you know, that this happened, and therefore we want to leave, but what we'll do is we'll want our pylon paying, which is payment in lieu of notice. So he had a 3-month notice period, so we want 3 months money paying in cash up front without him actually having to work that. And then we'll also go for an additional 3 months ex gratia payment, which is just a payment for all the hassle, and basically ties him over until he's got his new job, which he's going to have. He's going to be unemployed, whether it be on the dole or not. You know, he was on about 70 grand a year. You often find in employment that your typical client is going to be on, you know, something like over 30 grand probably, if you're on the claimant side. People who are kind of struggling to pay the bills, you know, it's something that I really enjoy helping people like that through my website. On my website, I give so much free information. You know, it's probably more free information than any other website in the UK about employment law. So that's available for everyone, and people can go and help themselves on there, and they can download our legal templates and watch our videos and so on. But if you want one of my lawyers to represent you, you know, that's not going to work if you're on that kind of money, because you're not going to be able to afford to pay our fee at the end of the day. We do a lot of percentage-based fees, where we will charge a percentage of what we get our clients. So, you know, I find that works really well because the lawyer's on the same page as the client. Whereas an hourly rate, clients are a bit scared of those generally, and you know, often lawyers, I think mainly due to American TV, but lawyers can have a bit of a bad rep, you know, for charging so much money. People are scared of them. That's possibly because of the hourly rate model, when people get a huge bill with lots of zeros and they didn't get what they wanted. And you can't get that with a percentage-based model, because if you're going to get a bill with lots of zeros, that means you've got lots more zeros, you know, in your bank account. So that's a good one to mention as well. The other thing I would probably mention is that my lawyers that work for me are on a 50-50 fee split. Okay, so they're not on a basic wage, they're not on a salary. So it's great with employment because on the claimant side anyway, by the way, not many firms do this. That's not normal. A, that's not normal. B, the percentage deal with the client, that's not normal either. So we're pretty different from other firms, but the reason it works really well with employment law is because you can be one person, you can get one case for one person, and that's your case. Whereas, you know, perhaps in corporate M&A, mergers and acquisitions, or, you know, certainly in a lot of corporate stuff, you might be on a team of lawyers. So you might be doing a case or a client, you know, in a team. So how would you ever split that up and decide who did what? So you couldn't pay someone 50-50 on that. Whereas actually on what we do, you know, it works perfectly because it's very well defined who's done what, because it's just that lawyer did that case. I'm quite proud actually. I don't know if you've checked out my website, but one of my lawyers got elected in June. So she's now an MP, and you know, I've been to see her in Parliament, and so it's, you know, it sounds like a perhaps strange model, but really it's actually a pretty good model that a lot of quite cool and senior lawyers actually sign up to now. So yeah, with John, we put this in a without prejudice letter. Now the other side came back and they said, without prejudice, no deal, we're not accepting. Oh, sorry. One of the things in my letter I put was that their treatment almost was tantamount to a fundamental breach of contract. So this is constructive dismissal. We're calling this constructive dismissal because you haven't dismissed us, but by sending us to Birmingham, you're basically forcing us to leave. And nothing against Birmingham, but it's quite a long way from Manchester, right? So they've come back with a without prejudice letter saying, no, sorry, no deal. We're not gonna settle this case. However, they also sent an open letter saying, we note that you have you've raised certain matters which basically almost amount to a grievance. So against your line manager who has, had this meeting with you. So we want to investigate this. So we're inviting you now to a meeting where we're going to discuss this. So you are allowed to, I don't remember if you're allowed to, you don't have the right to bring a colleague in an investigatory meeting. But so they're putting the pressure on him now. And I always think of this as kind of sending your client into the lion's den, because whenever they want your client to have a meeting with them, what they're going to do is sit there and grill them and make them feel uncomfortable. So your way is kind of, you keep your client employed, or if they're anxious and stressed, you tell them to go and see their doctor, maybe they go off sick or various other things. Subject access request, where you request the HR file, the whole file that the company has on them. That's another great tactic that you can use. Again, not really very legal, kind of is, but it's under Data Protection Act, right? So you request every single email or letter or text message or SMS that has mentioned your client under the Data Protection Act, just as you could write to any company out there who you've ever opened an account with online, or an account with in a bank. You could ask any organisation to give you all the data they hold on you. You do that in an employment situation, that's a great tactic to use. Employers, they like to get your client into a meeting. So what do you do at this point? What do you do when someone takes your without prejudice letter that you wrote, you're thinking that was confidential, or that was off the record, right? Then they extract the information that you put in there and put it into an open context. So how would you deal, has anyone got any ideas? How would you deal with that? What do you do? Did you go to the meeting? Do you refuse to go? In which case, are you not, by refusing to go to a meeting about an issue at work, are you not basically quitting then? Your boss is allowed to tell you to go to a meeting, right? So it's a difficult position to be in. And again, that's really about trying to outthink your opposition and trying to work with your client and have a really good kind of close rapport with your client, so you can kind of work as a team. And what we decided to do there was to say, right, okay, we're not going to, although they've said they're going to close the without prejudice conversation down, we've written back without prejudice saying to them, we're not closing without prejudice, and we're not going to this open meeting, because what you're doing with this is a kind of underhand. You're almost sort of disrespecting the doctrine of without prejudice. I'm sorry, but there's no legal term, because the doctrine of without prejudice is a common law doctrine, right? No one really knows where it came from. You could probably trace it back to some case in the 1800s, but it really is just a doctrine that's been built up. And the whole point about this doctrine is that everyone sort of respects it. It's almost like a tradition that it's supposed to be off the record. So by taking the information in my client's without prejudice letter and putting it into an open context and making him come to an agreement, you're almost sort of disrespecting the without prejudice doctrine. So therefore, we're taking this as another act which contributes to this fundamental breach of contract. So this is actually constructive dismissal. By doing this, you're making this employment relationship unbearable. So in fact, you're really just strengthening our case here by taking this kind of underhand approach. And we're not coming to the meeting. But what I said to him as well is don't send that, because they invited him to the meeting the next day. So right, don't send it tonight. Just send it tomorrow morning, just before the meeting, because it's legitimate. Why would you expect them to? They can't expect you to reply to something after 5 p.m. or something like that. So just because you normally work till 8, well, don't send it. Send it at 9. And he said, well, I'm going to see that guy in a group meeting with 11 other people. I'm actually going to see the HR director. I'm going to be sat around a big table with him and a load of other people. It's okay, great. This is actually perfect, because this meeting's going to be now awkward for them. So they have failed now to get you cornered in a meeting on your own, but you're in a group meeting where you're going to be sort of eyeballing this guy, knowing that you're not turning up to his next meeting, and he actually had a meeting booked in at that time when he was requested to go to that meeting. So, you know, there is it's almost like a game of sort of snakes and ladders. There's so many moves you can make, and both sides, it's like a war of attrition. You know, but it's something that's over quite quickly. It's normally done within like a month or two. So like big cases, big kind of commercial litigation cases where everyone's suing each other for hundreds of millions and so on, business to business, they can drag on for years and years, right, in the civil courts and the high courts. Employment disputes, it's normally like a specific problem that's crystallising, going to go in, you know, and the traditional people so people who are kind of chair people of banks or really senior people in big businesses, they almost always have their own employment lawyer. So they'll actually, when they get a job, they'll negotiate a contract with that institution via their employment lawyer. So even when they, in a job interview, they might be negotiating the pay packet or the benefits, you know, the share options. Shares is a huge thing. If you're going to be, perhaps you're creating a startup, you're creating Uber, you're going to hire the next Travis, whatever his name was, and he's going to have his employment lawyer and he's going to come in and negotiate that contract. In the same way, when they're leaving, they're going to have their employment lawyer coming in as well and negotiating them an exit. There's a certain like level of employee in terms of financial remuneration. Anyone earning over X amount is going to have an employment lawyer, is going to expect a settlement agreement, exit package. One of the things we're trying to do is actually throw this out to everyone in the country. So why should just kind of rich people have access to this kind of information? So we're just giving that information out for free on our website and trying to make it as accessible to everyone as possible. And okay, you're not going to be able to hire us individually to work for you because you're not going to be able to afford our bill, but you can use our kind of template letters and adapt them and put your name in and change the dates and so on, try and get yourself a deal and watch all the videos and so on. And the beautiful thing about that is that it's for me anyway, the rich people that hire us, they're kind of paying for that. And actually not only that, but they're actually getting paid by huge multinational corporations. When they leave, their exit package, so we're getting a slice of that, and then we're kind of putting that back in, you know, into the field out there. And really, most people out there, they don't know what employment law is. They don't think it affects them. And if you read the papers, a lot of the newspapers will tell you, well, we're talking about red tape here that's strangling our economy and all these things like rights, you know, that people have like paternity. Now you can have a year, I think, if you're a father, or a year if you're a mother who's just given birth, and then you can split it between two of you and so on. So all these rights that people have, strangling business, you know, with red tape. Actually, you know, if you look at economies like Japan, Germany, these economies they're actually more powerful economies than ours, you know, significantly. They have a lot more rights than we have in terms of employment rights. It's actually a lot more difficult to fire people in those countries. And that kind of often gives people a sense of stability. So it can make you feel more settled in your job. Right? I'm not just going to get sort of done over. If my line manager is a bit of a nutter, you know, they're not going to be able to get rid of me. Just like that. And actually you'll probably be less likely to kind of get home and just open a bottle of wine and kind of drown your sorrows and kind of, you know, get ill or be unhealthy, or just generally kind of your whole quality of life. You know, a lot of, in our country, I feel we're still a little bit Victorian, this kind of notion of having to work hard all the time, especially in London. It's a little bit, you know, I find it's counterproductive, and giving people kind of access to employment rights and the knowledge and the way to use those rights, you know, in their scenario, it kind of really brings it into the 21st century. And kind of, I think it's good for everyone. It's good for the economy. Okay, in America, you know, that's the example where they've got less rights than us. I mean, they really have no rights there. You could be working for somewhere for 20 years. Someone could tap you on the shoulder, your boss rather than someone, but tap you on the shoulder and say you're fired, and not give you a reason. And so long as it's not discriminatory under the sort of protected characteristics, you know, race, religion, you know, nationality and so on, then, you know, there's nothing you can do about it. But I think obviously America's a slightly sort of special case, and no one's really saying that we should try and be more like America. at the moment. So yeah, I mean, there's a good reason for having these. It's quite good fun getting them. I suppose I'll just wrap up by just touching on how we get our work, okay? Because, you know, as I said earlier, no one's really using this business model that we're using, and it's very difficult to get claimant work because there's no kind of groups of employees that get together. I can't go and do a talk to a bunch of employees who are being fired because it's a very solitary thing getting fired, and it'll be one person from this company, one person from that company. There's no kind of groups. Whereas if you're working for a respondent side, i.e. if you're working for HR and so on, you can go and do talks to like whole rooms full of HR people or to companies and tell them all about employment policies and rights and tell them all about, you know, protected conversations and without prejudice, so on. So we are very kind of rare breed out there, but we're getting our work mainly through Google. So we're kind of appearing quite high up on Google for various search terms. I know that you searched our, searched for constructive dismissal and we came up for that. So we're doing that by being quite sort of digitally friendly. So we've got like a team of coders. I've got some kind of real mathematicians there that are able to make really fast loading functional websites. We've got like a calculator that tells you, you know, what you should get in a settlement agreement deal. And we've got designers, people who make it look good. You know, Steve obviously doing the videos. I don't know if any of you've seen any of the videos we've done. We've done some quite funny videos. You can look them up after the talk. They are genuinely quite funny, like almost like comedy videos. We're trying to kind of give it a bit of a comedy element to make it more of a topic that people will talk about and to make it more of a like less of a taboo topic to actually have, you know, rights and stand up for them really. So yeah, I can do a couple more examples or not, or any questions, or I don't know, people, you know, might want to go home or what. I've got till 6, but I don't have to use it. So I guess any questions for a start at all?
What sort of claims do you mostly do?
So constructive dismissal is our classic one where someone's still employed, they're being treated badly at work, you know, and it might be, let's say you've got a salesperson, their commission structure has been completely changed. That could be a grey area. What, you know, what's their entitlement of the employer to do that? Or it might be a subtle change. They might have taken away, you know, Asia, but given them, you know, South America, and it might have changed their pipeline. You've got to looking at the impact of that, how to get them out of there with a reasonable deal. But certainly we do constructive dismissal, a lot of that, where they just want to negotiate settlement. Employment tribunals, I've done quite a few of them, and I do the talking and stuff in those, but I don't do them anymore. And actually, they're a nightmare. You can go on for a year or two. Any litigation that you do, and I've done Comlit as well, it's stressful as well. You're going into court, the preparation you have to do, the paperwork. You can literally have lever arch folders full of paperwork. Like you can easily have quite a few of those. Have to learn all of them, where all the evidence is, which page relates to which witness, and write all the questions out. The last trial I did, I think it was a 6-week trial. I was literally sleeping about 4 hours a night and literally working every single minute of the day apart from like eating. So it's not, although it's fun and exciting, and when you're winning, it's actually good. It's really exciting. But when you're looking at it as a quality of life thing, litigation can get super stressful. People feel very strongly about it. It doesn't matter whether it's criminal, whether it's commercial, whether any scenario where you're in court, you know, okay, that's stressful. And there's no real winners there apart from the lawyers, because by the time that the judge has given judgment, you know, both sides have burnt up so much in costs. So anything where you can kind of negotiate, that's a way out for both sides to negotiate a deal. You know, actually that's a lot more fun in terms of your lifestyle as well. So as a lawyer, it's important how your quality of life is as well. Because I don't know, I kind of work to live more, and that's something that lawyers obviously get a bit of a raw deal with. Hours, you know, especially in big firms like Magic Circle firms, the expectation to work so many hours, So yeah, litigation. But on the other hand, if you're doing something just pure corporate, where it's all just kind of non-contentious, so you might just be like reams and reams of paperwork. And for that reason, on the non-contentious side, there might be a different kind of like a problem with quality of life, and this might be boring. So something like a bit of a middle ground type of law, where you're kind of negotiating some kind of amicable-ish / possibly not amicable at all, but negotiating some kind of deal. I mean, in family law, people do that, don't they? And they negotiate settlements between, like, husbands and wives that are splitting up. I don't know how amicable those are. I mean, potentially bring their own kind of stresses, especially where children are involved and so on. So yeah, we do. That's why we can really focus on negotiating specific quick exit packages, that are just people leaving. So that's kind of why we focusing on that area of law. Yeah. Right. Any other questions? Okay. Thanks for coming, and yeah, cheers. Cheers.